Good morning, everybody. We're about to start work visa options after OPT. Before we get started, I just wanted to introduce myself. My name is Fuji Whittenburg. I'm an attorney here at Wolfsdorf Immigration Law Group. We are a medium-sized law firm located in Los Angeles and Santa Monica, and we practice exclusively in immigration law. We also have an office in New York, if any of you are on the East Coast that are listening in. And basically, I'm just going to run through what your options are after you graduate and after OPT. Obviously, the timing is really good. We've got the H-1B TAP April 1st deadline coming up, so I'll be discussing that as well. If you'd like to receive our newsletter, please visit our website, and you can enter your email there and sign up if you want to get updates from us. You can like us on Facebook, follow us on Twitter, all of the usual things. And also here's my email address. So if for whatever reason you either need to clock out early, or if you have a personal question or any questions at all actually throughout, please email me and I will try and get back to you as quickly as possible. It may take several days, obviously, especially now. But please feel free to email me. And then you can also, I believe, before we get started, use the chat function and send emails there as well. Okay, we'll get started. So for those of you who are graduating, I mean, some of you, just the basic terms, I will go through OPT a little bit, but you should, you know, if you have specific questions about OPT, you should always speak with your international student office. They have a lot of knowledge and experience with OPT, as well as CPT, obviously, too. So CPT is curricular practical training, so you can actually work during the school year under certain circumstances that have to be related to your degree, but your international student office, they can actually authorize that for those of you who need to work, you know, during school, not on-campus employment. This is different. This would be like if you wanted to work outside at a company. And then OPT is what most of you get after you graduate once you finish with your degree. How long does it last? Well, for most, generally speaking, it's 12 months. But, you know, recently they just added the STEM OPT. So in addition to the 12 months, you can actually extend the OPT for another 17 months, so you get a total of 29 months, or just over 2 years. But this is only specific for people who are graduating with a bachelor's or higher degree. I get this question a lot. So bachelor's or higher degree in science, technology, engineering, or math. It's only those degree programs. There's actually a designated STEM degree program list, and it's at the website that I have listed here. It is at it's the ice.gov website I have. You have to check to make sure that your degree qualifies, and it has to be in those specific degrees. In addition to that, there are 2 other requirements. The job must directly relate to your degree major. So if you got a degree in engineering and you want to extend your OPT to work as an accountant, unless the 2 are really related, you can't do that. And then also the employer has to be registered with E-Verify, which is, it's just additional government oversight. So some employers aren't as inclined to register. Some are already. You'd be surprised. But, I just wanted to address this because a lot of people think that everybody who gets OPT can also extend it, their OPT, which is not true. And then also, they don't realize that even if you have a STEM degree, they think it's automatic, which it's not. You have to have a job. It has to be related to your degree, and the employer has to be registered with E-Verify before you can even extend it. So that's OPT. And then there are unemployment periods for you guys to be aware of. For those of you who are, just starting your OPT period, perhaps this is good to know ahead of time. For those of you who are finishing up, also this is, probably information you already knew, but there is 90 days of unemployment for the regular, and then 120 days if you have a STEM extension. And how to avoid it, you need to volunteer at the very minimum, or intern, even if you're not getting paid, minimum of 20 hours in your field of study. if you can. So, and also a bit of advice, stay in close contact with your international student office. You know, different schools vary in their reporting requirements. Some are much closer with their students than others, and actually keep track of this. So it's a good idea for you also to report, if you're not working, to report any volunteering or internships, you know, if it's a week or whatever it is. Make sure you report that to your office so they can keep track of it if you ever need it. And then another thing you can always do is get a letter from whoever you were, you know, kind of interning for, and say, this is to confirm, you know, she interned with us from, you know, March 1st to March 15th. You know, she worked 20 hours a week, this, you know, doing this. Something simple like that. My biggest piece of advice, you know, don't forget to apply. For those of you who are graduating this fall, please, 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 whatever you do, make sure that you apply for OPT. It's the only time that you're really going to have this kind of a government freebie, as they call it. I mean, there is a filing fee, but it is 1 year, at least 1 year of work authorization. So please, please make sure you do it, even if you plan on, you know, going home or moving to, you know, London or whatever it is. It's good to have just in case. You can apply as early as 90 days prior to your program end date or 60 days after your program end date. Always check with your school for exact filing dates because, again, it really varies, and it's based on the program, your program. So make sure you check with them, and you can use it as a stepping stone to find that employer. You know, it's a good opportunity without, you know, asking for an employer, which I know a lot of you who are graduating or interviewing are concerned about, you know, how do I address the visa, you know, question, or if I need a sponsor, should I tell them at the beginning, should I not, can they ask me, can they not? And I know it's already a precarious situation going through the interview process, and to add this, I know it's just an added layer of uncertainty. So it's a good idea if you have the OPT. That way you come with work authorization. You don't have to ask your employer for anything, and then hopefully they'll be so, you know, dazzled by you, they'll want to sponsor you for H-1B, you know, after your OPT is done. Okay, so let's say you do your OPT, you're finishing up now, and you want to apply. What are your options? Obviously, the elephant in the room for everybody right now is the H-1B visa. The April 1st deadline is looming. Our office is busy. We're filing H's, and you know, it's probably the kind of the most popular visa, I would say. It's for those of you who are entering into professional occupations. What is a professional occupation? It is one that requires a bachelor's degree at a minimum in that field to perform the job. So, you know, I know it sounds very direct and straightforward. The government always has a way of complicating things, and so it's not as simple as it sounds. And I'll get into that a little bit later, but, you know, in terms of a professional occupation, it does need to be, you know, I list some of the more classic examples here. Obviously, there are thousands of occupations that qualify, but it is what, you know, what you think, what comes to mind, you know, an accountant, an engineer, a computer scientist or software engineer, things like that, graphic designer, although they don't really consider a graphic designer sometimes. So those would be, you know, some examples. The H-1B visa is employer-specific, so you can only work for the company that petitions or sponsors your H-1B. You can have multiple employers, so let's say, and it can be part-time or full-time. So let's say you have two employers that want, you know, that you want to work with. They can each sponsor you. It'd be two different H-1B visa applications, you know, in part-time capacity for you, and you would have both of those visas. Otherwise, you can't work for another employer outside of your H-1B visa. So that situation I just talked about, that's concurrent, having a concurrent H-1B if you want to work for multiple employers. There is a 6-year maximum. It's granted in 3-year increments. So you file now. It's good for, you know, the maximum petition period is 3 years. And it's not that you're tied to that employer for the full period of time. It's at-will employment, so they can lay you off or you can leave. So that's at will. And then portability is where you would file a change of employer. You can actually transfer your H-1B to a new employer where you won't be subject to the cap again, but you would have to still file a second H-1B petition. It's doing the whole thing all over again. It's not as, people are like, oh, I can just like transfer it, carries over. No, you actually have to file something, but you do, you can do it, and you would be able to start working as soon as it's filed. I just went backwards. So the H-1, what I talked about, the cap or the quota, when I keep saying, what is it? It's something that, every year, and it's based on the fiscal year, the private industry employers are given a quota or a cap on the H-1B visas, and it's $65,000 per fiscal year, which isn't very much these days. And then there's a carve-out within that 65 for Singaporeans and Chileans, and then there's an additional $20,000 for U.S. graduates with a master's or higher. So what that means is that your master's or PhD or doctorate or higher degree has to be from a U.S. school. It has to be a U.S. degree to qualify for these additional $20,000. So the cap, some timing issues. Just to give you guys a little bit of history, a lot of you guys are younger or unfamiliar with what we used to call March Madness. But before the economy kind of tanked out a little bit, there was something called March Madness where everyone would apply on April 1st. We would all file our petitions on March 31st. It arrives at USCIS that first day, that first week, basically. They would accept H-1Bs, and then it was a lottery. So there would be a computer-generated lottery. They would just, everybody would file. They would go through and at random pull petitions. And if your application was selected, you would get a receipt notice. And getting that receipt notice was kind of like getting, a letter in the mail saying you had just won the lottery. So that's how it used to be. And then in 2009, when the economy kind of took a nosedive, just employers were not hiring, and it just didn't happen that way. So everybody across the nation would filed less applications. So it opened on April 1st, and it would actually just stay open for months and months and months. Whereas before, it would, all the visas were used up that first week, and it was a lottery in terms of who got it. So it was a very drastic change. So that first year, it stayed open from April until, almost the end of December. So good, 8 months or so. And then the following year, it stayed open even a little bit longer in 2010, all the way from April 2010 all the way to about January, end of January 2011, which is a lot longer. And then last year, and then then 2011, it stayed, kind of pulled back a little bit. Last year, the cap was met in June. So it just, it was like 2 months. And so that was obviously the shortest H-1B filing season since 2008. So based on all of that, and probably what you've heard in the news recently, we are, we're kind of expecting a very short cap season this year. So for those of you who do have H-1B, employers willing to sponsor you, you should file as early as possible. How early can you file? The earliest is April 1st, which is just in a couple of weeks. So my advice is, if you have the option, you should go ahead and file. If you don't, obviously there's nothing you can really do. Hopefully you're on OPT and it's not an issue, and there's always next year. H-1B gap relief, something I wanted to talk about. It applies to all F-1 students who timely file H-1B during the acceptance period. So basically on or after April 1st, as long as you file your H-1B petition before your OPT expires, after April 1st, before your OPT expires, you are given, this gap relief where your F-1 status is automatically extended, and if you're working, your work authorization on your OPT is also automatically extended until September 30th, or just before October 1st, and at which point hopefully it'll hopefully it's approved before then. And if not, for whatever reason, you have 60 days from the date that it's denied. But CAP-GAP is nice because before they gave this, people would have to, let's say their OPT expired in June and they got an H-1B. It didn't start until October. Between June and October, they would have to go home basically, or just be here or not work, and it was really difficult. So I have a nice little chart here that kind of, gives you, it's based on last year's dates, but it gives you an idea of, if you graduated last year, you started your OPT, right now you're on your OPT, you file in a couple of weeks, your April, the April 1st CAP deadline is met, and as long as you file it before July, which obviously you would, then your work authorization is extended until October 1st. It does have to be approved. This is something else just to throw in there. Because of processing times, last year, I think some of them took up to 6 months. So sometimes, well, if you file on April 1st, hopefully 6 months would be October 1st, you would know. But if for whatever reason it takes longer, or the cap isn't met and you file in May, you do have to go off of payroll. It doesn't extend beyond October 1st. It only gives you, to get to October 1st. So you would either have to go off of payroll, or you can upgrade your petition to premium processing if you haven't heard. Usually I tell people if you haven't heard by mid-September, then I would go ahead and upgrade to premium processing so that you don't have to go off of payroll or stop working. Okay, what is the process? The process is, let's see. Basically, the agencies involved, USCIS and Department of Labor. The Department of Labor steps are done in the beginning. We have to verify the tax ID number, the FEIN, it takes a few days, and then the LCI, which takes a week. So this is important in terms of timing for those of you who are ready to file your H-1B but haven't started. I would advise getting started as soon as possible, because there are a couple of steps that need to take place. It's not like, you can say you want to file it today and, it can be done tomorrow. There's a little bit of wait time here. Once the LCA is certified, then you can actually file the petition, which is where, you draft, or hopefully you have an attorney or somebody helping, but, everything's submitted to USCIS. That's the agency that actually adjudicates the petition. Just a couple of, common RFE issues. An RFE is a request for evidence. And we've been, last year, there was something that they like to pick on. They do like to ask if it's a specialty occupation, which is what I was talking about in the beginning, the professionalness of the occupation. They're all on the Department of Labor's website. Each occupation is designated. There's an ONET classification where a lot of occupations that we consider professional, like a graphic designer, for some reason in what's called the ONET, it says, some employers require a bachelor's degree, but others may not. Because they say that, but others do not. So even if 99% of employers require a bachelor's degree at a minimum, but there's that one employer out there that doesn't, because they'll accept somebody who has 10 years of experience or 15 years of experience instead. USCIS will sometimes take the position and argue that it's not, in fact, a specialty occupation. It doesn't require a degree at a minimum, and they basically want you to demonstrate it, using other things, whether it's industry standards or what their hiring practices are. In the past, they've always hired somebody with a bachelor's degree to fill this role. The duties are so specialized that no one other than somebody with a degree could do it. That kind of a thing. So that's sometimes a problem with some occupations. And they'll pick on, financial analysts too. I mean, it's just, it's kind of, to me, a little random, but it's an issue a lot of people have been having. They can also pick on the employer. It's not to say, startups are okay. You can sponsor someone, or you can be sponsored by a startup. It's really about the viability of the company, whether it has the ability to pay your wages, their wages, overhead costs, the rent for the bill, all of those things. They just want to make sure that it's a real company, and then it'll be there, enough to support your position. And then, kind of going back to the specialty occupation bit, they'll say that the degree isn't related to the occupation, or accountants would, it requires a degree in, accounting, economics, finance, something like that. So they can pick on little things. I just wanted to point that out to a few of you guys that are interested. Sorry, I'm trying to, there we go. Employer obligations, they must pay you the prevailing wage, and you can find this at this link here, the flcdatacenter.com. That's also where you can find, look at the occupation and see whether or not it requires a degree, or if, I'm sure it does. It's just whether or not they classify it as having or requiring a degree. Employer obligation, they can't bench you just because it's a slow season. They can't withhold work and pay and say, oh, we don't need you right now. In the petition, they are making certain attestations, whether it's part-time or full-time employment, and that you're being paid a wage, so they have to stick to that. And then when it comes to termination, if for whatever reason, things don't work out, or the company isn't doing well, and either you're laid off, or if they lay you off, they have to offer you reasonable cost of transportation home. That does not include your family members, just you. And they have to, they are required to notify USCIS. And I say that because a lot of times, people aren't aware of that, or an employer will say, oh, no, don't worry, we're not going to report it or anything. They should, so you would want to find a second option as quickly as possible. Another popular question, who is responsible for all of the fees? Hopefully, the employer is going to pay for everything. That's the ideal, that's the ideal case. Of course, I know in the real world that doesn't really happen. So if the foreign national or you do want to pay, or are, they're asking you to pay any of the fees, before you even think about it, you have to at least be paid the prevailing wage, which is published at that link I was talking on the other page. So, I'll give you an example. It's published, so it's something that you can't really argue around it. But so let's say the prevailing wage for your occupation is $60,000, and you're being paid $60,000. You can't pay for any of the filing fees or the legal fees, because by paying that, you'll subtract. Let's say, the total is $5,000. That would be subtracted from the 60, so that would actually be $55,000. So that would be below the prevailing wage. Who will know? I will know. You will know. And no, I mean, it can come up later. They could, at the embassy, when you're going to get your visa at some point, they can ask to see, I don't know, payroll records or something like that, or they can ask you. Actually, that's how it comes up. I forgot. They can ask you, who paid for the fees. But anyways, so that's, but let's say you are making, the prevailing wage is 60 and you're getting paid, 75,000. Hopefully that's the case. The training fee has to be paid, must be paid by the employer, and I put a 750/1500. It's one or the other depending on the size of the company. So if it's less than 25 employees, it's $750. If it's larger than 25 employees, it's $1,500. And then the other government filing fees, this is kind of a gray area. In some in some regulations or publications or memos, it says this, and sometimes it says that. So really, you should consult with an attorney. But I mean, I think the $500 fraud fee should also be paid by the employer, because That's my gut feeling. So that should also be paid by the employer. But then the I-129 $325 fee, you could possibly pay it, and then obviously there's an optional premium processing fee of $12.25 to the government that the foreign national could also pay. And then same with legal fees. I mean, same rules apply as long as you're making above prevailing wage. It can be paid by either the foreign national or the employer. But hopefully the employer is paying for everything. Okay, H-1B audits. I'll just touch on this really quickly. No funny business. There has been an increase in fraud investigations and worksite visits. I get calls all the time from clients saying, "Oh, we just had, ICE was just here. We just had someone stopping by, and they asked to see, they asked to talk to me, so that they can ask to speak with the HR person. They can ask to speak with you. They can show up, ask to, what do you do here, on a daily basis. They want to make sure you're performing the duties of the H-1B position. So, if we said you're an accountant, you're not, sitting up front as the receptionist answering phones. They can also ask to see payroll records to make sure that you are being paid that prevailing wage that was in the petition, and they ask to see, like, who signed this petition, and that's the person they talk to. For those of you who have spouses and children, there's an H-4 visa. There's no employment authorization that comes with it, but they can go to school. Some other, information about the H-1B. The cap does not apply to extension, so you only have to be counted once. So you only have to worry about it one time. Beyond that, if you're filing an extension or a change of employer, you just go ahead and you don't have to worry about the April 1st deadline. There is a remainder option, so if anybody listening has previously had an H-1B and you didn't use the full 6 years, so my example here, H-1B, you went back to school and then H-1B, you can actually use the remainder of that time that you have left over. So let's say you only used it for 2 years, you would still have 4 years to use, and then so you could do that. Or you could just file a new petition, but you would be subject to the cap. What happens when you reach 6 years? Is 6 years really 6 years? Well, yes, it is, and no, it's not. There is a maximum, but there is an exception. For those of you who apply, or down the line, if the employer is going to sponsor you for a green card, there is a way to extend the H-1B beyond 6 years. And I list a couple of things here. You have to have, either the I-140 or labor cert pending for more than a year, or the approved I-140, and you can extend it for 3 year in 3-year increments. So that's for, usually this is of concern for people who are from countries that are backlogged. Oh, I skipped over. You can recapture time spent abroad. So this is good to keep track of. For those of you who are getting started on H-1B or who will be getting started, you should keep track of any time that you go home on vacation, whether it's a month over the summer or a month around Christmas, or you go to a friend's wedding in Mexico and you stay for a week or two. All those little trips, or also business trips, any if you're a frequent traveler and you go to Europe a lot or whatever it is, add up all of those things, because we definitely have people where they add it up. It's really like 6 months worth or a year's worth, and you could use that at the end. So you have to keep track of it, whether it's passport stamps in your passport or flight itineraries, whatever it is. It's a good idea to be aware of that. Top 10 myths about the H-1B visa. I mentioned some of these already as we were going through this. You can have an H-1B for a small company or a startup. It's not unheard of. If it's a startup, it's about kind of explaining what it is. Having a business plan. Hopefully, there's a lot of funding. If it's a startup and it's got $1 million or $2 million backup, or in investment funds, that's obviously very strong. If there are reputable people who are behind the company, or partnerships, that kind of a thing. So it's good to you always want to build the full picture. Must advertise the position and show there's no qualified U.S. worker. That's not true. That's I think people confuse H-1B. That requirement is for the perm labor certification green card process, where they have to advertise and do run Sunday ads and all of that. For the H-1B, there is no such requirement. There's a posting requirement that the employer has to post, a notice within the office showing that they're, hiring, one worker in this position, and they're going to be paying that person this much. But that's internal. You can change employment. You can do that at any point. It doesn't have to be, April 1st, or there's no timeline on it. It can be any day of the year, as long as you have a new employer. You don't get a new 6 years every time you change employers. These are all common. I mean, it sounds silly, but these are actually like real questions I get all the time. So I wanted to, it's always good to share this. There's no grace period after layoffs. If you are laid off, your status terminates immediately. Hopefully you have a good relationship with your employer and you have notice, so that you do have the opportunity to find new employment and at least get the H-1B change of employer petition started, if not filed. You can go to school part-time on the H-1B. Schools accept H-1B. So for the, sometimes people want to do part-time, do a part-time evening master's program or something like that. It just depends on the school, but you are eligible. You can't file under the master's cap before completing your degree. So for those of you who are, graduating in May, for instance, of this year with a master's degree, and you're filing on April 1st, so on April 1st, you will not have graduated. You won't have your degree unless you can get a letter from the registrar saying that, he or she has met all degree requirements, like every single thing, and is just walking in, May of 2013. If you can get something like that, then you could file under the master's cap. But otherwise, for those of you who are graduating, you would have to file under the bachelor's cap, which is fine. And something I forgot to mention, if for whatever reason, those of you who are, filing under the master's cap, if the master's cap is met and there's still visas available in the bachelor's, your application automatically falls into the bachelor's cap. It doesn't increase your chances of approval. You're not prioritized or anything, but at least, you get to, dip in both pools. Premium processing increases chances of approval. I wish, but it doesn't. In fact, some would even say that filing by premium processing increases the chances of an RFE, because they have to respond within 15 days, and sometimes if they're super busy, this is my theory, they just need to buy more time. They'll just send you a request for evidence. So something to keep in mind. This is all theory. It's but it doesn't at the very least, I do know it doesn't increase your chances of approval. It doesn't look good or anything like that. So I just wanted to throw that out there. And then no one will check if you're actually working. We talked about that earlier. They do have work site visits and audits and things like that. So there is always that possibility. And then the last one, you have to have a U.S. degree to qualify. That's not true. Even if you have a foreign degree, it's okay as long as it's evaluated and found to be the equivalent of a U.S. bachelor's or higher. So for those of you who are in the master's program now but won't graduate by April 1st, then you can, and you have, let's say you have a degree from, I don't know, Romania or something, your bachelor's degree is from it. You can use that bachelor's degree. You just have to make sure you get an evaluation from an agency here in the U.S. Okay, so let's say, we'll fast forward a month or two, and the cap has been met. So now what? What are some other options? There is another H-1B option, which doesn't, operate under the April 1st CAP deadline. These are for CAP-exempt organizations. So the CAP is for private industry. There are H-1Bs for CAP-exempt organizations, so universities, nonprofit, research organizations, et cetera, and they can file at any point throughout the year. They're not subject to the CAP. They don't have to worry about, applying by April 1st and starting October 1st. So for those of you, let's say you're interested in, working at a university or being an assistant professor or anything like, related to that, you could file for the H-1B in that way. So this may be a good option for some of you who missed the CAP and have some opportunities to work at a nonprofit. This is something to explore. And then you can't, if let's say you do that, you work for a university for a couple of years and then you want to switch back to private industry, at that point you would be subject to the CAP. So that's also something to factor in. So that's pretty much the H-1B. Some other, alternatives would be the free trade visas, which are all kind of lumped in under here. So for Chileans and Singaporeans, which I talked about earlier, there's an H-1B one. There's the TN for Canadians and Mexicans, and there's an E3 for Australians. The TN visas for Canadians and Mexicans, even those two are actually kind of different. I mean, there's one list, I list it here, the TN appendix, where it lists all of the occupations. The H-1B is good because it's super broad. It includes, everything under the sun, in terms of occupations. The TN is very specific. You have to look at the appendix, but not all occupations are on that list. So you have to check that. And then, but all of these, by the way, all of these visas require, they're all, kind of professional occupation visas, and you have to show that you meet certain requirements, that you have a bachelor's degree. Also on that TN appendix are the requirements, and different occupations require different things. Not all of them require, absolutely a bachelor's degree, but so that's something to mention. Canadians apply at the border, a pre-flight inspection when they're coming in, and then Mexicans have to apply at a U.S. consulate in Mexico. But the TN is good because there's no filing fees, government filing fees, which when we went through like the H-1Bs, that can be pretty substantial depending on the size of the company. So that's nice. And something that, and then also it's adjudicated on the spot. You get an answer like right there. Same with E3s. E3 visas for Australians. You apply for the first one. You apply at the U.S. consulate in Australia, and same thing. You just apply there. They give you an answer, and hopefully the visa is issued, and you can come in and work on that. J1 visa for exchange visitors. This doesn't really apply to a lot of you that are in school if you're currently in school in the U.S. This is for people who may be listening from abroad, but it's good for exchange visitors to be an intern trainee. And there's also J1 for professors and research scholars. And then if any of you are on the J1 visa, just make sure you're aware there's a 2-year, for some people, some countries, 2-year home residency requirement. It's something that's actually like annotated on your DS 2019. H3 trainee, that's another type of training visa. We have been successful for applying for somebody on OPT to an H3. It's counterintuitive because the OPT is optional practical training, so arguably you should have received training already on the OPT, but we've been successful in the past if we can, with the H3 even, which could be an option just if you can show the training's not available in your home country and it'll benefit your career abroad, you plan on going back. So, for example, I don't know if it's in finance, and you want to be an HC trainee, on Wall Street, I would argue that you wouldn't be able to get that sort of training in your home country if, depending on where you're from. It's one of those things. It's more about argument, but these are some options. There's also the L visa. L is in Larry. Multinational executives and managers is the L1A, and L1B is specialized knowledge visa. So this is an option for those of you who were possibly employed, within the last 3 years. So if you're a student listening, that would be almost impossible unless you're in a master's program, because you have to show one of the last 3 years, within the last 3 years, that you were working for that company abroad. But for those of you who are graduating, maybe you have an opportunity with a multinational, like a large company, and like Nike or something, who has offices abroad, and they give you an opportunity. They're like, okay, well, we have a position in, in Singapore or Tokyo. Why don't you take that position? And then, maybe in a couple years we can transfer you to the U.S. This would be great. You could go, and hopefully it's, a manager type position, and you would go work there at least for 1 year, but maybe longer, and then they could, again, if they want, if they're on board, transfer you to the U.S. in this position, in this visa category, and it's, it's really based on the corporate relationship of the company abroad and the U.S. company. So, anyways, it's an option. It's something, to be aware of. You can do a new office L for new companies. So let's say you're graduating, you go abroad, and they don't have a U.S. office yet, but they're doing really well and they want to expand into the U.S. market. They can actually send you over to the U.S. to set up that new office in the U.S. It's only good for 1 year, so it's not really, it's not, it's still a little chancy, but it is a good option. And after that 1 year, if you can demonstrate you've hired some U.S. workers, you've increased revenues, things of that sort, and you've increased clients, or whatever it is. All of the goals that any new business has, as long as you can show that it's grown, then you can request an extension. And then, hopefully you can get it, the full, and then it would be just an L1 visa. L1A, you can only have a total of 7 years. L1B, total of 5 years. L1B, and I don't know if I didn't go into too much detail, but it's specialized knowledge. It's, really proprietary knowledge, not just, I'm on board, or I'm aware of the company's best practices or something. I get the way that they market, or it's not internal stuff. It's really having like a very proprietary technical knowledge of something like the secret formula of Coke, or some sort of program. You're the only person in the company that knows how to do this, like programming or something like that. And and I guess the standard I should mention that you can't train someone to do in 6 months. So it would take more than 6 months of training to train a U.S. worker to do that. That's also a good benchmark. The good part about the L visa is that spouses and children receive the L2, and then that's not the best, but it's the EAD, the Employment Authorization Card for the spouse that they get to work as well. And then there's also a green card process that's nice and tidy from this. So it's basically saying a lot of the same thing as the L. There's a lot more documentation, but it's a great option. Another option for those of you who are, kind of entrepreneurs and business people, there's an E1, E2 treaty trade and treaty investor visa. There has to be a treaty between the U.S. and your home country that you have it's a passport, your passport country, and you can check the treaty country list at travel.state.gov. But at least half of the company, 50%, has to be owned by the treaty country national, so by you. Half of it has to be at least that much. You can't own like a 5% ownership by you and then 95% owned by, a U.S. citizen, that's not going to work. It has to be at least half owned by you. And then you can also start up a company or you can buy a company. So my most classic example is, you set up a company. That's obviously very straightforward. Buying a company, if you buy a Quiznos, or it doesn't have to be exactly a chain like that, but you get the idea. You can purchase it, and that'll be your investment. The treaty trader is the E1, so you have to show trade between your home country and the United States. So it's for those of you who are into the import-export business. The E2 is the, kind of just setting up a company and running it, whether it's a production company or a restaurant or, something like that. You have to show for the E2 that you have made a substantial investment. And how substantial, is substantial. It's not really quantified, but, I mean, we typically say, more than 150,000 at least, and then it has to be placed at risk, and that's their words, not mine, meaning it can't just be money sitting in a bank account. It's money that you have to have actually spent, not all of it, not every penny, but, at risk, meaning, you've purchased a property or you have a commercial lease, you've bought equipment. If it's an office, you've gotten computers and you've set up the phone, utility, all of those things which cost money, furniture. The restaurant's always the easiest for me to, give it as an example. You have the space, you have a sign, you got the menus, you have the tables, the tablecloths, the cloth napkins, the plates, all of the kitchen equipment, and utensils and all of those things. It's pretty easy to add up. It's going to be harder to do for people who are service-oriented, because if it's just you sitting at a computer with a phone, it's really hard to show that money has been spent. So anyways, this is something to consider, but it is a good option. And then, spouses and children, almost, I think, all dependents get visas. Not all get work authorization. The E, just like the L, spouses also get a work permit. My favorite, I'm just kidding, there's the O1 visa. I just happen to do a lot of O1s. There's the O1 visa. It's for those of you, it might not be an option right when you graduate, but maybe down the line, whether you use up all of your H-1B time, or for people who were really well established in their careers before they came to the United States for, degrees, this would actually apply for you. It's in, there's the O1A and O1B. There are two classifications. O1A is science, education, business, or athletics, and O1B is a separate, kind of, and then within O1B there are two subcategories: arts, which includes, artists, musicians, art director, graphic designer, that kind of a thing, sound engineer. And then there's motion picture, TV, actors, writers, and everyone else. So, these are little subcategories, but it's extraordinary ability. And you have to show, you have to demonstrate you've reached a certain level. And then there are O2 visas for essential support personnel. So usually, motion picture TV is the easiest one. So for a director, they need their assistant director, that they worked on, for other movies. They want to bring them over. O3s are the dependent visas, and there's no work authorization. Just quickly, the visa standards. The O1A is the highest, I would say, obviously in this category. You have to show that they have demonstrated their extraordinary ability has been demonstrated by a level of expertise indicating that the person is one of a small percentage who has risen to the very top of the field. I know it's heavy language. Then there's the O1B arts, which you have to show that you are of distinction, high level of achievement in the field as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. And then film and TV is slightly lower, it's very high level of accomplishment. So I've underlined, O&A, small percentage, O&B, high level of achievement, and O&B, high level of accomplishment. In terms of types of evidence, this is a question I get all the time too. It's just, these are some, the criteria detail these kinds of things, but it's, prizes, awards, memberships and associations, not just like being a member, like paying dues and then just being a member, but like where they have associations that have like a selection criteria, having press or having, publishing materials yourselves about you or your work, having publications. So if you're, let's say a scientist, publications are a big part of your career. So having, having been published or being, in a journal or judging the work of others, being on a panel, authoring, conference presentations, having a critical or leading role for a company. So having, being the founder of a company or something like that, or, being the head coach of the football team at, Alabama, something like that. High compensation and salary, that's another criteria. Commercial success, that's really more motion picture TV. For artists, display of your work at exhibitions, reference letters, and any online evidence, things like that. So some job search tips, not that you're asking, but, I think obviously the social networking sites are great, all of the classics, LinkedIn and all of that. I think also talking to your school career services office is a good idea, Chamber of Commerce, your local embassy or consulates. Everyone's always surprised that, they may be advertising, some, like if at the German consulate you're German, a German person living in the U.S., maybe they have a company and they go there and they post jobs there. You never know. And something I would highlight in an interview setting, obviously your international perspective and how it's a, competitive advantage. It's a global economy, those kinds of things. I would really highlight, in addition to hopefully your impressive qualifications anyway. Okay, so those are that was just kind of a nutshell overrun of the NIV, non-immigrant visa options. Now we'll switch over to the immigrant visa, green card options. First, there's nothing you can do right now, but just like the OPT, this is another freebie that I feel very strongly about, green card lottery. There is a lottery. I don't know how long it's going to last. There's been a lot of news lately. They may be taking this program away. So if you haven't heard of it or applied before, there's a green card lottery. Go to travel.state.gov. They give away 50,000 green cards every year, and it's a very, very short registration period. So it's October. It's really the month of October. I say October, November, but it's really like it opens October 4th until November 4th. The exact date changes, but it's always that month of October, basically. So right now, obviously it's closed. But if you are eligible, only certain countries are eligible. There's no application fee. You just upload a photo. You complete the form online. It's very, very straightforward. It's based on your country of birth, not your citizenship. So that's always surprising for some people. So hopefully, maybe you were born somewhere, but you're a citizen of a different country. That's, so look at that very closely. But, countries that are not eligible, I've listed them all here. And that's because there's already a high population of that nationality in the U.S. So that's why they're not eligible. That's why. And you can cross-charge to your spouse's country of birth. So even if you're not eligible based on your country of birth, maybe your spouse is, and you can file through your spouse. So that's one. That's the green card lottery. Check it out. Hopefully it's still available in October. And then the two other options, they're either family-based green cards or employment-based green cards. So I'll just briefly touch on family-based green cards. There's the immediate relative. green card. So that's, for if you have for spouses, spouse, parent, or minor children of U.S. citizens can apply. You do get immediate benefits. So that means once you file, within about 2 to 3 months, you get work and travel authorization, and it's about a 6 to 8 month processing time. It's pretty quick. For marriage cases, if you've been married for less than 2 years, you do only get a 2-year conditional green card, and after that, you have to apply to remove, the conditions. Life happens if you're in school here and you are, dating someone or engaged or talking about marriage, this would be the option here for you. Another common question really quickly is, my child was born here in the U.S. Can they sponsor me? No. I mean, yeah, so yes, they can, but once they reach 21. So if they were just born, if they're 2 years old right now, you have to wait, 19 years before they're eligible to sponsor you. Just to, go through there are backlogs depending on the category. So that first category is immediate relative. That's the quickest. Then there are these other categories. So adult children of U.S. citizens, backlog. And I don't know, this may not be the most updated. You have to check the visa bulletin. This is published every month and it changes. But for the most part, this is how it is. But so as you see, relatives of U.S. citizens, or there is a distinction between relatives of legal permanent resident. So an LPR is a green card holder. So, if your spouse has a green card, there's a 2 to 3 year wait time, for you to get your green card and so on. And at the end, you see brothers and sisters of U.S. citizens. So for those of you who have a sibling who's a U.S. citizen and they want to file for you, there's a long, it's a 12-year backlog, which is tough. It's something to factor in. As students, your F-1 visa, you remember your F-1 visa interview, you do want to be aware of filing a green card, because it is something that if it has been filed, you do need to disclose. And so it just kind of depends on your home country and all of that. But, in terms of renewing a visa, the F-1 visa, you have to, you're saying I plan on, I don't plan on, I don't intend to immigrate to the U.S. So having filed a green card application is, obviously contradictory. I forgot to mention this during green card lottery. Green card lottery is not, you don't have to, like when you're answering that question, have you ever filed for a green card? The diversity visa lottery is what it's called, does not count. So you don't have to worry about the green card lottery and having immigrant intent. Okay, and then the last one are employment-based immigrant visas and employment-based green cards. So they run EB1 through EB5, EB being employment-based, and then 1 through 5. So EB1 is first preference. This is kind of like the O1 visa, aliens of extraordinary ability. I mean, amped up, but then there are also, this is also good for, there's the outstanding researcher and professor category, and then multinational executives and managers, like the L visa we were talking about, fall under the EB1 category. It's, it's the fastest. There are no wait times in terms of, there's no backlog, I shouldn't say there. There's always the government. There's always a wait time, but it is a quicker green card process. Obviously, the criteria are more burdensome. The standard is higher, so it's hard to prove, but it's a good option. Then there's EB2, which is the second preference category, and that's for advanced degree holders. There's also what we call SCEDE Group 2, alien of exceptional ability in the art sciences or performing arts, and there's a national interest waiver petition, the NIW, which the EB1 I forgot to mention, that's self-sponsored. That's the biggest distinction and probably the biggest attractive quality about it. But the EB2 has to be sponsored by an employer. The national interest waiver, if you file it under a national interest waiver, it can be self-sponsored. So that's something, that's important to a lot of people because people don't want to be, tied to a particular employer. But it's really difficult to self-sponsor. Then there's the EB3 third preference category. This is the largest category with the most applicants, and probably, it has the longer wait times. Everyone's trying to get into the EB2 category, but EB3 is, it's the same. A green card's a green card. So this is for, professionals with a bachelor's degree, skilled workers, and other workers fall under that category. Blank. Process, step 1. Okay, so the EB2 and EB3 processes, if you go through the PERM process, which is, again, the most common one, for those of you who are graduating, do your H-1B, then PERM, it's a labor certification process. So this is the one where I said you have to advertise, with the H-1B it gets confused with the PERM process. For this, the employer must conduct good faith recruitment efforts and show there is no qualified U.S. worker to do the job. How do they do this? They actually advertise. There are certain, venues that, recruitment venues that you're required to publish and advertise on, different forms of recruitment, I should say. And, they publish them in the Sunday newspaper and advertise for your job. And the HR person gets resumes, and then they have to go through them one by one and kind of show this person, oh, this person doesn't have a degree, or this person doesn't have this experience, and so on. So they go through and kind of weed out the resumes. If they do find somebody that is qualified, then you have to stop and start all over again. They don't have to let you go or anything, but you do have to start over. So anyways, but that's the first step. Hopefully that's certified. Step 2 is the I-140, and step 3 is the I-485, which is the adjustment. With the adjustment, that third step is where the work and travel authorization comes. So you can't, unless you file step 3, you have to have an underlying visa if you want, in order to continue to work. So this is the big distinction between EB2 and EB3. For EB2, most categories, except for India and China, you can file those two steps 2 and 3 together. But for EB3 and if it's backlogged, you can't file step 3 until your priority date, which brings me to this. This is from the March 2013 Visa Bulletin, again, travel.state.gov. It's updated every month. And as you can see, here's a little chart, employment-based. So EB1 is C's all across. C means current. EB2, second preference, all countries except China and India are current. And then in the third pref category, it's kind of random, but everybody's backlogged. And then specifically, China, India, Mexico, Philippines, those countries, if you're born in any of those countries, they're backlogged, in varying degrees. Retrogression is what they call it when it's backlogged like this. And then it's based on your priority date, which is the date of filing your PERM or filing the I-140. So that's why, people want to just get a priority date, because it's just like you want to hurry up and wait. But it's just a matter of the way I explain it is just, you are waiting, you wait in line. So, the earlier you get in line, the sooner you get to the ticket window. So that's my easiest way of explaining it. But as I was saying, if you're retrogressed, you can't file that third step, the adjustment, until your priority date is current. So you have to maintain underlying visa in order to work, and that's the tough part for a lot of people. Just a few, things that may come up, deciding between the two. It's really actually not for you to decide, because it's not based on your background, the way that it happens. It's based on the minimum requirements for the job. So if your employer wants to sponsor you to be, a senior software engineer, they have to publish that, and their requirements have say, oh, we require for this position a master's plus 3 years of experience, or we require a bachelor's plus 2 years of experience, or whatever it is. Hopefully, obviously, you meet those minimum requirements. That's the whole point. But if it's a bachelor's degree, then if they only require a bachelor's degree, then it's EB3. And if it's a master's or higher, or a bachelor's plus 5 years of experience, it would fall under EB2. Tricks that don't work: tailoring to your experience, adding a foreign language requirement, if it's totally unrelated, you would have to show the necessity, the business necessity of it. So you can't just, throw in, they can't add random requirements. It would probably trigger, those are red flags, it would trigger an audit. And, people have different attorneys have different thoughts on this, but I don't think you can use employment experience, or not that, but I meant the unauthorized employment. You can't use that. If you're trying to meet, if it's bachelor's for 5 years, should all be authorized. You want to make sure that you have H-1B visas to match all of that. And then you can't use employment experience with the same employer. That was what I was saying. So if it was in a different position, yes. But if it's experience in the same position, you can't use that towards meeting the requirements. When to get started on the green card process? Obviously, the sooner the better. If, for those of you just starting out, you work on your H-1B for a year or whatever, visa. If we were working for the company for a year and they, they love you, you love them, they want to get started, obviously you can get started. But we typically say no later than 4.5 years into the H-1B, just because you want to make sure certain steps are met in case there is a backlog and you do need to extend your H-1B beyond that 6-year period. So that's where, we kind of want to make sure that you're aware of that. But also you want to make sure you like the employer and vice versa, because it can be a long process. The 2 other green card categories, I just want to mention them. EB4 is the religious worker immigrant visa, and then there's the EB5, which is what a lot of people have heard about. It's where you make an investment. It's either $1 million or there's a $500,000 requirement. The $500,000 regional programs, it's a pre-approved program that the government has already approved, where you invest money. It's a pool investment. So the $1 million one, it's just you can basically set up your own company. You have to create at least 10 jobs, but you have full reign over it. The regional center or the regional program's $500,000 one, it's just pooled. You don't really have a whole lot of say in anything, but it is an option for those of you who have generous and wealthy family members, or you yourself can afford to have that. It's a great option. Okay, so we finally come to an end. I hope I was able to give you a broad overview of what your options are post-graduation in terms of visas and green cards. But if for any reason I didn't address something, or you have more specific questions that you would like to ask of me, please feel free to email me. My email address is fwittenberg@wolfsdorf.com. You can visit our website, and we have updates there as well as some information. And you can read more about our firm there. And again, another plug to like us on Facebook and follow us on Twitter. Sign up for our newsletter. But above all else, if you do have questions, please feel free to email me, and I will try to get back to you as quickly as possible. And we have other webinars actually also advertised on our website. So if you would like to sign up, I give these pretty regularly, but we also have some different presentations that are more specific. Thank you for listening, and good luck.